Yes, Majority Leader.
Mr. Speaker, if it pleases you, I shall proceed to respond to the submissions of my respected colleague, the Minority Leader. First of all, he argues that there is a precedence in the matter he has raised, and the presidential value of it is what he wants you to give effect to. In his own narration, he also argues that the political party which the member then belonged to petitioned the Speaker. And based on the petition, the Speaker took a decision. There is no petitioner before this House. No political party. If you keep quiet to listen, we listen to him in silence. This is a serious legal matter. Mr. Speaker, his argument is a political party wrote that its member has vacated his seat. And on the basis of that, an action was taken. That set of facts are completely different from what he's trying to force on us. There is no such petition from any political party, be it his own political party or our political party. So I just want him to understand that that argument has no leg to stand on. It falls flat. It sits on stilts. That is a preliminary matter. That's a preliminary matter, which he got it wrong, and he wants to mislead Mr. Speaker. Mr. Speaker, having addressed that, he says that he comes before you under Order 93. Order 93. 93. And 93, all he says, and I quote, "By the indulgence of the House and the leave of Mr. Speaker, a member may explain a matter of personal nature or make a statement on a matter of urgent public importance at the time appointed for the statement under Order 67. With the greatest respect, Honorable Minority Leader, if you want to invoke the rule, invoke it rightly. What you are trying to do by inviting Mr. Speaker to make a ruling has to do with a statement. The provision does not clothe you with that power to make that application, and that you should get it. Mr. Speaker, the provision that you quoted, you got it completely wrong. You got your rule wrong, and you should know this. Mr. Speaker, I don't know why he was taking the wind out of the sail of the Honorable Harun Idrisu. Mr. Speaker, this morning, the respected former leader of this House, former Minority Leader, Honorable Harun Idrisu, filed a petition before you on notice. The petition that he filed, he served him a copy, and I have a copy with me. The admissibility of the petition is entirely in the hands of Mr. Speaker. But Mr. Speaker, the petition is titled, "Notice of Petition to You to Declare Vacant Seats for 4 constituencies." Honorable Harun Idrisu says, "I wish to notify you under Order 99 of Standing Orders of Parliament on the need for you to declare a vacant seat of the following constituencies: 1. Aguna West, 2. Suhum, 3. Amenfi Central, and 4. Formina." He goes on to say, quote, "I will be doing so under Order 18 of the Standing Orders of Parliament. Vacancy other than resignation of Article 97 1B to E, G, and H of the Constitution, Mr. Idrisu concludes by saying, the Speaker shall inform the House of the occurrence of vacancy of the seat of a member under Clause 1B, 2E, G, and H of Article 97 of the 1992 Constitution, duly submitted, dated 15th October 2024. Mr. Speaker, the minority is in disarray. In one breath, a member is petitioning you, and in another breath, somebody else having the position of minority leader is also invoking Order 93. Which is which? Mr. Speaker, they are in total confusion as to this mischief they want to invite on this floor. Mr. Speaker, let me remind them that per your ruling, Mr. Speaker, per your ruling in the Adwa Safo case, dated October 26, 2022. Mr. Speaker, this is what you had to say in the Hansard of 26 October 2022, 4th Series, Volume 117, Number 2. And you use these veritable words to express your view. And quote, column 3 of the said ruling. The decision on whether or not a seat is vacant is one that must be carefully considered, and for which our Constitution and courts, as well as all the rules and best practices of other parliaments, have provided significant guidance. Our job as a House will not be to usurp the functions of any arm of government, but simply apply the law faithfully and in accordance with the dictates of the 1992 Constitution. In view of the antecedents of the objection raised by the Honorable Majority Leader, it is necessary to recount the facts of the matter before us from its inception up to and concluding the stage it has reached before the House. Mr. Speaker, it went on and on and on, where the issue of proper procedure in determining the Adwa Safo case was espoused by you. Mr. Speaker, having put out all these facts, let me concede that this is a serious constitutional matter. Let me concede that this is a serious constitutional matter which has different views being expressed. I am a practitioner of the law and a student of the law. Having come across this controversy, and for the sake of posterity, I have initiated, Mr. Speaker, an action at the Supreme Court. Would you remain quiet for me to argue? I listened to him in silence. Would you remain quiet? That is democracy. You must remain silent and listen to me. You would have to be quiet and listen to me, and you will listen to me, and you will listen to me. You will listen to me. Yeah, you will listen to me. This is a legal argument. Ama Kofi Boa. This is a legal argument. You have to listen. This is a legal argument. You must listen. Mr. Speaker, I have invoked the jurisdiction of the Supreme Court to aid us. And this is in accordance with your own ruling, that these are matters that we need the courts to come in. Mr. Speaker, this process has been duly filed. I have the writ with me. Not only the writ, it's not a naked writ, it's not a lame writ, Mr. Speaker. I also have accompanying the writ a motion or notice for interlocutory injunction, which is also attached to it. the process, Mr. Speaker, has been duly served on Parliament, as I'm made to believe. Mr. Speaker, I am of the view that this is not a matter that anybody can just get up and say that by virtue of a member filing a process to say that I am going to contest in a future election as an independent candidate, automatically I have lost a seat. Mr. Speaker, let me take members back to memory lane. In the 1960s, the First Republic, where, Mr. Speaker, there was cross-carpeting in Parliament, 69 Constitution and 79 Constitution safeguarded the process where political parties were to be protected, and 1992 Constitution also adopted that provision. Mr. Speaker, it is therefore important for members to understand that practically you cannot say that once a member belongs to a caucus and has not resigned his membership of the caucus, the mere fact that he has filed to participate in future elections under a different ticket, he is caught by a certain provision of the Constitution. Mr. Speaker, I hold my view. I've heard other views contrary to this. That is the more reason why we require patience for this matter to be properly determined by the courts. We require patience for this matter to be properly determined. Somebody cannot say that, oh, there is a certain precedence. So relying on that precedence under Order 93, Mr. Speaker should just make a declaration. Mr. Speaker, this application, so-called, is leading you into a certain valley of confusion. It's a trap being set for Mr. Speaker for his long years in legal practice. Yes, because you simply want Mr. Speaker to make a declaration which will have far-reaching consequences. In any event, a man must be heard. The rule, all the ultram partem rule, the rule is clear. A man cannot be brought to judgment unless he's been heard. If you claim, then it was bad law. If that is what you want to say, if you want to, that's what you want to say. It was, would you keep quiet for me to argue? Mr. Speaker, I need to be protected from this stubborn minority chief whip. Kwame Agboja has been a very stubborn minority chief whip. Yes. A man must be heard. It doesn't matter. You've been there before. Mr. Speaker, a man must be heard. The individuals whose matter is being raised are not in this chamber. They are not here. And your party member, your party has no petition. Have you, as General Secretary, written any petition that you've sacked him? And then he's not here. Even if there's a letter from the General Secretary that Honorable Aka has been sacked from NDC, he has to be heard. He has to be heard. A man must be heard. The rule is that if all men find a man's hand in a till, his guilt must still be proven. You cannot just get up and say, Mr. Speaker should make a declaration, declare somebody's seat vacant. Mr. Speaker, I will not belabor. I've put out the preliminary issues. I have also faithfully explained to you the processes before the Supreme Court of Ghana on this matter. Mr. Speaker, I have also submitted that there is a petition before you. And Mr. Speaker, the Harun Idrisu petition, if you look at it, it means that you are supposed to refer the petition to Petitions Committee. What they are doing, they just want a short circuit. And that is what Honorable Atu Forson is trying to do. Dr. Forson, this is law. This is not economics and taxation. You should know this. The lawyer has filed a petition, and you are using backdoor to create confusion. You want to mislead Mr. Speaker. That's what you want to do. That is what we want to do, Dr. Forsen. That is what we want to do. The lawyer in Harun Edrisu has invoked the proper procedure. You just got up, you want to short circuit by saying order 93.1. Who told you it is order 93.1 that you have to use? He has used the proper procedure. Wait for Mr. Speaker to admit. And then upon admission, we proceed on the rule. Even so, the petition will be caught by the court process. Mr. Speaker, it cannot be. Mr. Speaker, they want to mislead you to truncate our democracy. Mr. Speaker, you've been part of this democracy since 1992. Mr. Speaker, through your experience, you got elected as Speaker of Parliament. Mr. Speaker, this is a moment for you to make history, to defend this democracy. Mr. Speaker, not to subject yourself to the whims and caprices of desperate minority leader. A desperate minority leader who does not want to follow procedure and law. Mr. Speaker, don't be tempted, Mr. Speaker. Don't be tempted. The law he relies on sits on stilts. I repeat, there's a proper petition. Let's wait for its admissibility. Because that has been done by a lawyer who knows the rules. Harun Edrisu is a respected lawyer. And we know that. Yes. This is a lawyer's rule. You know that. This is done by a lawyer. If it's issues about tax and economics, I will yield to Atu Forsen. On this occasion, it's law. It's law. So let's go by the Harun Edrisu petition. That is the right procedure. But even so, that petition will be caught by the court process. You cannot proceed. You should know this. And you want to mislead, Mr. Speaker. My duty as a leader of government business, my duty as a majority leader, my duty as a majority leader is to guide, Mr. Speaker. I remain so. It will not change today. It will not change tomorrow. I am guiding Mr. Speaker. I don't want you to lead him into temptation. Mr. Speaker, don't be led into temptation. I rest my case without more.
Yes, Honorable, is that Dominic Aine?
Yes, Right Honorable Speaker, thank you very much. Mr. Speaker, the majority leader has waxed lyrical on the legal implications of the statement made by the minority leader, the Honorable Minority Leader. Mr. Speaker, what the minority leader invited you to do was basically to adhere to precedent. Mr. Speaker, this House is governed by a number of legal instruments. The first is the Constitution of the Republic. The second is our standing orders. And of course, decisions of the Superior Court of Judicature. Mr. Speaker, the matter that has been raised is legitimately one of public interest. Why? Because there is a constitutional provision that deals with the issues that the minority leader has raised. And that particular provision deals with the balance of power in this House. In other words, the constitutional purpose of Article 97(1) is to deal with the balance of power in this House. And basically what it says is simple, that whenever a member who has come into this House on the ticket of a party decides to go independent, the Constitution says that that member shall vacate his seat in Parliament. The language is mandatory. And the reverse is also true, that when you come in as an independent and you then decide to join a political party, you shall vacate your seat. And the language, Mr. Speaker, once again, is mandatory. Now, the question is whether objectively the actions referred to by the minority leader have actually taken place. Is it true that these members elected into this house on the ticket of the two major political parties have suddenly decided that they are going independent? Now, the minority leader referred to 4 persons or 4 members of parliament who have taken steps contrary to the constitution. The majority leader in his delivery has not denied that that has happened. Objectively within the public domain, Mr. Speaker, these persons have not denied that in the case of the second deputy speaker, that he has decided to join the New Patriotic Party, or let me say rejoin the New Patriotic Party, because he came into parliament initially as a member of that party, when independent, was the subject matter of the ruling that the minority leader says you should, adhere to. Then, as an independent member, he decided to caucus with the minority. There is nothing constitutionally, with the majority, there's nothing constitutionally wrong with that. But then, he has decided to join the New Patriotic Party. And in the language of the Constitution, when he makes that decision, he shall vacate his seat. Now, Mr. Speaker, the Constitution does not provide a procedure by which you make a determination as to whether or not, or how the person vacates the seat. Okay? Now, the majority leader was at pains to emphasize that there is no petition before this house, or that there is a petition by the former minority leader, but that is not the subject matter of the statement being made by the current minority leader. Mr. Speaker, the constitutional provision is triggered merely on the basis of objective available facts relating to the actions taken by the member of parliament. It is not as to whether another member of parliament or a member of the public or the political party to which that person belongs has petitioned this house. That's not what the Constitution says. In fact, it beholds on the member, if that member does not want to violate the Constitution, in which case they will be charged for high treason under Article 3 of the Constitution. It beholds on that member not to step foot in this house. That member must vacate the seat as enjoined by the Constitution immediately. So there's no need for a petition. The fact that the New Patriotic Party, in its own desperation, in respect of the honorable member for Femina, sent a petition to your predecessor, which was the basis of the eloquent ruling, which we are inviting you today to stand by. Mr. Speaker, you are not, by law, you are not bound by the ruling of your predecessor. But we are saying that what the Right Honorable Aaron Michael Okwe, Professor of Political Science, that ruling, that erudite ruling that he delivered, we are saying that, Mr. Speaker, you should stay by this ruling. Mr. Speaker, the only difference in terms of the presidential value, Mr. Speaker, I need to be protected from the heckling by the majority leader. This is not fair. When he was speaking, he was waxing lyrical about the fact that this is law. I'm not teaching him law. He should listen to me. He should listen to me. Mr. Speaker.
Sit down, respect.
Sit down and listen to the professor.
Mr. Speaker.
What is that?
So, Mr. Speaker, no, I respect leadership.
No. Sit down.
Okay, no, keep quiet and listen.
Madam Speaker, we will not be interrupted.
Sit down.
We will not be interrupted.
Sit down. You called me name.
What's that?
No.
Honorable members, please resume your seats. Resume your seats. Resume your seats. Please. Both members, please resume your seats. Honorable members, the minority leader made a statement under Order 93 on a matter of urgent public importance. That was what the minority leader did. He made a statement on a matter of urgent public importance. By our rule, any member is by the rule permitted to comment on that statement. That is exactly what we are engaged in. And so after him, the majority leader had the opportunity to comment on it. As to what constitutes comment is a different issue. But that's what our rules say, a member is to comment. And so now another member, Honorable Dominic Ayine, is also making comments on the statement. I think it's important we allow him also to do so, and I'll give any other member who wants to add his voice to it by way of comment before, if I'm disposed to, making a ruling. If there is a need to make a ruling, I'll do so. If I think that the issues raised are so weighty that there's a need for me to take some more time to delve into it, I will do so. So please, let's have some order. The Honorable Dominic Ayine should be given the opportunity to continue with his comment and to complete so. Mindful of the time limits, I will ask members, I don't know how many of you want to make comments on it.
All of us.
But please,
I'll see my time.
I'll give you sufficient time to do so. Yes, Honorable Dominic Ayine.
So, Right Honorable Speaker, thank you very much for the protection. Mr. Speaker, I was on the point that there is no need for a petition before the action contemplated under 97 and Article 97(1)(g) can be taken. And I said that because the New Patriotic Party in its desperation brought a petition before the Honorable, Right Honorable Mike Okwe, does not necessarily mean that it is that procedure that will necessarily trigger any action under Article 97(g). Mr. Speaker, the majority leader has also indicated, and I was really ached by what he said, that he has filed an action in the Supreme Court. And in respect of that action, he has also asked for an injunction enjoining Parliament from taking any action in respect of this matter. Mr. Speaker, Parliament hasn't yet taken a decision. In fact, in the context of Article 2 of the Constitution, it is an act or omission of a person which violates the Constitution, which triggers an action before the Supreme Court for either an interpretation or an enforcement of the Constitution. Mr. Speaker, the majority leader knows that to take an action in anticipation does not comply with the letter and spirit of the Constitution. In fact, the Supreme Court made it very clear in Tufo and Attorney General that it does not give advisory opinions. What the majority leader has done is basically asking the Supreme Court to give an advisory opinion on a matter that, in respect of which Parliament hasn't yet taken any action. And as a leader of the House, I think that what he's doing, or what he has done by taking that action, is basically weakening the power of Parliament. It was in the same for an Attorney General that the court said that whatever happens in Parliament is a closed book. And the majority leader is behaving in a manner that then opens up Parliament to scrutiny, especially when we have not yet taken a decision. What he's simply doing is that he's asking the court to basically gag Parliament. Mr. Speaker, do not allow yourself to be gagged. Mr. Speaker, the members of this House will not be gagged by the actions that he has filed. We are going to speak out on this matter, and this House will perform its constitutional duty to take a decision with respect to the actions of the members involved. Thank you very much, Mr. Speaker.
Yes, Honorable Joe Gatti.
Mr. Speaker, thank you very much for permitting me to speak on this very important matter. Mr. Speaker, I will start with a procedural point and go on to speak about the substantive issue. Mr. Speaker, the respected minority leader chose to come under Order 93. And Mr. Speaker, I won't read it because we all know it. But Mr. Speaker, Order 93 clearly sets out what can be done if a member decides to come under that order. And Mr. Speaker, Order 93(6), and I'll read that, says, where a member makes a statement, the Speaker, considering the comments of the statement, may direct a committee to investigate and inquire into the matter. And the last part says, and when necessary, propose legislation. But this is not about legislation. So, Mr. Speaker, a statement is made. First of all, the statement has to be admitted. But because of the urgency of this matter, I don't think I'll even belabor that point. Order 93(8) says that the clerk shall make available to members copies of the admitted statements. But because of the urgency of this matter and the seriousness of the matter, I will not also belabor that point. But Mr. Speaker, when you look at Order 3, Order 3 says that, Order 5, 2. They say in any case not provided by these orders, the Speaker shall decide on the procedural question. Mr. Speaker, as far as Order 93 is concerned, it is clear what will happen to a statement made under Order 93. And we have been in this House for a long time. When you decide to make a statement, after people will comment, that's what you are doing. When we finish commenting, if the Speaker thinks that the comments are such as to raise a serious issue, you refer the matter to a committee. The committee will go investigate the matter and bring its report. Mr. Speaker, the question of how to enter into Parliament in a particular matter lies entirely in the bosom of the person who intends to bring the matter to Parliament. And Parliament is a house of procedure. And so therefore, you cannot decide that you can bring any matter anyhow to Parliament, no matter how serious, and expect Parliament to take a decision on it. For example, in matters of statements, Parliament does not vote on it. It's clear. In matters of statements, rulings are not made on it. What happens is that the matter, if it is serious enough, is referred to a committee. Mr. Speaker, I will not, for me, my good friend Honorable Abuja, me and him, we know each other very well. When I used to be, with my previous deployment as Railway Minister, he was ranking for my ministry. He used to heckle me a lot. So I'm used to his heckling. Yes. I'm just joking with you. Mr. Speaker, so as far as Order 93 is concerned, the 93. Mr. Speaker, as far as Order 93 is concerned, or the 93-1 is concerned, it says what can be done. Mr. Speaker, to come to the substance of the matter, the procedure is even as important as the substance, if not more important. Because, like a court of law, Mr. Speaker, we have to come properly. If you don't come properly, you're out. And Mr. Speaker, I need not remind you respectfully that when I started practicing, you were some of the brightest stars as far as our practice was concerned. And I know that you are a man of procedure. And procedure was one of your strong points. And I know you are still a man of procedure. People have urged you to rely on the decision of your predecessor, Speaker Justice Michael Quay. The interesting thing about the standing orders, which has always intrigued me, is that even the Speaker himself, unlike the courts, where when the Supreme Court is departing from his decision, it must state why. In our part of the world where we work here in Parliament, a Speaker is not bound by the decisions of himself or even the previous Speaker. And in fact, the facts that were given in respect of that case are quite different than the facts that are given in respect of this case. Mr. Speaker, I come to Order 97. I'll come back. Mr. Speaker, I come now to Article 97(1)(g). It says that a member shall vacate his seat if he leaves the party of which he is a member at the time of his election to Parliament to join another party or seek to remain in Parliament as an independent candidate. We talk about the two members who have filed, who came in as NPP members and today have filed to be independent candidates. They haven't left their party to join another party, so that doesn't apply. They haven't also sought to remain. This is the 8th Parliament. In the 8th Parliament, they haven't also sought, Mr. Speaker, you see, I mentioned the Chief Whip's name in anticipation of the fact that he will try and heckle me. And he started laughing and saying, where is glasses? You know, it was a preemptive strike. And Mr. Speaker, I was right in my premonition. He's my friend with whom I'm well pleased with. Mr. Speaker, it says that if he seeks to remain in Parliament as an independent member, none of the two members of Parliament have said that they are seeking to remain in Parliament as independent members. They are still NPP members. And you suggest, Mr. Speaker, it is suggested to us that the minute you file under the NPP's constitution, it means you are no longer a member. That is wrong. As far as the previous matter was concerned, NPP itself petitioned that the member involved was no longer a member. We talk about H. 97(1)(h). A member shall vacate his seat if he is elected a member of Parliament as an independent candidate and joins a political party. Honorable Esiama, second deputy speaker, has he told you that he's joined another political party? Because we were on this floor when Honorable Wayo Seni moved from one part of the house to another. The man was an NDC member of Parliament. He got up and made a statement that I no longer want to be an NDC member of Parliament. I am now joining NPP. He crossed across. I was in the chamber. He crossed and came to sit on this side and immediately left. There was no dispute. As my good friend, Honorable A.B. Fuseni will say, if a man dies in the marketplace, there's no need to do a funeral announcement. Honorable Wayo Seni had, as it were, died in the marketplace. He himself had said that he had moved from one side to another. So there was no dispute about it. In this case, why are we assuming that certain things have happened when they have not happened? In any event, Honorable Afenyomakin the revered majority leader made a very important point. He is my nephew with whom I'm well pleased. He said that political parties, he talked about the rule of natural justice, that no one must be condemned without beginning a hearing. He's not talking about only a hearing here. Even if the political party should take a decision that a member by his action, a member of a political party by his action has ceased to be a member of the party, that member has a right to be heard. That member has a right to be heard. And indeed, Mr. Speaker, it says in Article 55(5) that the internal organization of a political party shall conform to democratic principles, and its actions and purposes shall not contravene or be inconsistent with its constitution or any other law. The new Patriotic Party has not announced to anybody that the two members of Parliament are no longer members of its party. Neither has the new Patriotic Party told anybody that Honorable Esiama's situation has changed. Mr. Speaker, these are matters of deep interpretation. These are matters which lie strictly in the bosom of another forum. The forum has been told me by my friend Honorable Abuja. He has directed me where to go. He has pointed his hands that it lies in the bosom of the Supreme Court. The danger, Mr. Speaker, the danger, my colleagues and friends, is that if we are not careful, we will embark on a course of action that will seem to take the powers of one arm of government and exercise it in this forum. In fact, our standing orders keep on saying that if a matter is before court, we should keep it before court. Indeed, what Honorable Dominic Ayeni said about the Supreme Court saying that it does not give advisory opinions and so on and so forth, these are matters that will be argued there. With the greatest respect to Honorable Dominic Ayeni, I have a lot of respect for him. He teaches law, I also teach law. He's not only teaching law in the house. Yes, he teaches law, I also teach law. And I started teaching law before him in 1992. And I've taught law longer than him. So, with the greatest respect to Honorable Dominic Ayeni, my revered colleague, not just in Parliament, but also in the academic arena, these are matters that me and you know that are best suited to be answered by the Supreme Court. I am not saying for a second that Mr. Speaker is not competent to answer these questions in his own capacity. Mr. Speaker could have been the Chief Justice or could have been the Supreme Court. If he was in that forum, I am sure we'll all hear his views. In this forum, I tell Mr. Speaker that the distance seemed one step enough for him. Order 93.6 states what he can do in this circular. It says, and I end by that quotation, where a member makes a statement, the Speaker, considering the comments of the statement, may direct a committee to investigate and inquire into the matter. The Speaker, respectfully, in these circumstances, cannot rule. Thank you very much, Mr. Speaker.
Yes, Honorable, is it Mama Yarga? Yes.
Thank you very much, Mr. Speaker. Mr. Speaker, I think that we are dealing with very straightforward matters. I say very straightforward matters because Order 18 of our rules state clearly that the Speaker shall inform the House of the occurrence of a vacancy of the seat of a member under Clause 1B to E, G, and H of Article 97 of the Constitution. So, Mr. Speaker, strictly speaking, it is your province to declare the vacancy of a seat. It is your province. And you could act whether you are informed as such by a political party or because the matter has come to your attention as a matter of fact. It is your province. So, Mr. Speaker, what has just happened today is an attempt by a member of this House to bring to your notice certain factual matters, which matters establish that some members who came to this House on the ticket of political parties have gone to file as independent candidates to contest the next elections. And another member who came to this House as an independent member of parliament has gone to join a political party, because unless he joins the political party, he cannot contest on the ticket of that political party. So he's going to join a political party and has filed on the ticket of that political party. This is also a matter of fact. Mr. Speaker, all those who have spoken so far have not disputed these facts. They have not disputed these facts. And in fact, the Electoral Commission, I believe, has issued notice of polls, and these facts have become public. So, the issue is the minority leader, who I believe by this time should properly be addressed as the majority leader, is seeking to bring to your attention these facts as matters of urgent public importance. The question is it a matter of urgent public importance? Mr. Speaker, go to the interpretation provisions of our standing orders. And it says that minority caucus means the members of the party or parties that have the second largest number of seats in the House. It also says that majority caucus means the members of the party or parties that have the largest number of seats in the House. Why am I referring to these two provisions? Because if you do exercise your powers under Order 18 and confirm the vacancy of these 4 seats, a matter of urgent public importance will occur immediately, because the constitution of this very House will change. The balance of power will change instantaneously, because this side will cease to be the majority side, and this side will also cease to be the minority side, and this side will immediately become the majority side, and that side will become the minority side. This is why it is a matter of urgent public importance that the public should be aware of. So the question is whether or not it should be by a statement under Order 93 or by petition. Mr. Speaker, I think that if a petition brings the matter to your attention and you decide to act, fine. But also a statement under Order 93 can bring the matter to your attention so that you can exercise your responsibilities and powers under Order 18 of our standing orders. Mr. Speaker, I believe also that the question of the substance, because what I've said so far deals with the procedure, the question of the substance is also not disputed. Because if you read the two provisions, they are clear. But the majority leader, who I believe will soon be the minority leader, has stated that he has gone to court. I believe he's gone to court because he thinks there's something there that requires the consideration of the Supreme Court. That's up to him. But this House is governed by its rules. And the Constitution is clear that we are governed by our rules. And you and whoever sits there as Speaker interprets the rules. And the rules have been interpreted before and enforced in this House. And the position is that when a sitting member of Parliament, sitting here as a member of Parliament on the ticket of a political party, during the term of Parliament, decides to file nominations to contest as an independent candidate, this House, through a previous Speaker, has ruled that that person ceases to be a member of Parliament. The seat becomes vacant. That is the rule we have. What the Supreme Court will say tomorrow based on his, application there is a matter that tomorrow we'll wait and hear. But for now, Mr. Speaker, as we sit, the rule is that when you go and file as an independent member, to contest as an independent member, or vice versa, you cease to be a member of Parliament. That is the rule as we have now. You may agree with it, I may disagree with it. We may have our disagreements, and my disagreement with the rule is a matter of public knowledge. But whether I disagree with it or not, as we speak, that is the rule. And the rule benefited the NPP yesterday. And it should benefit the NPP today. I don't know why he is challenging. I don't know why he is agitated about it. I don't know why he ran to the Supreme Court even before Parliament resumed. But the rule is clear, Mr. Speaker, that if you are a sitting member of Parliament on the ticket of a political party, and when nominations are open, and you go and you don't file on the ticket of your party, and you go and file on the ticket of, as an independent, Mr. Speaker, this House, based on the ruling of your predecessor, deems the seat vacant. The same way, vice versa. If you come here as an independent candidate, a member of Parliament, and during the pendency of this Parliament, you go and join a political party, and you file to contest on the ticket of that political party, Mr. Speaker, the rule equally applies to you, and you cease to be a member of Parliament. Mr. Speaker, this is a simple matter. Like you have rightly noted, these are comments we are all making. It is for you to take a decision, whether or not you need even to think about it any further, whether you want to, guide us today and determine what the proper position is. But we are only drawing your attention to these facts, and also further draw your attention to existing precedent and the rules, and also draw your attention to the provisions of the Constitution. Thank you very much, Mr. Speaker.
Yes, Honorable Atachia.
Yes. Thank you, Honorable Speaker. I'm so saddened by what is happening in this chamber that I'm tempted to bring to the attention of Honorable Speaker of the Lord's Prayer. In the Lord's Prayer, Jesus said, "Lead us not into temptation, but deliver us from evil." Oh, that is a very serious statement. Today, I'm hearing for the first time that if you want to have majority in Parliament, you go to the December pools, but they are going to use your energies and your talent so they become the majority. That's pathetic. That is very pathetic. If you want to win and be majority, December is staring at you in your face. Why do you want to have the speaker with this kind of program? I don't understand it. I don't understand. You are running away from this, December 7th and you think that the speaker should aid you so you become the majority. Oh, this is pathetic. It won't happen today. It won't happen tomorrow. Honorable Speaker, let me ask something very important. Yes, it will happen today. It will, Mr. Speaker, you become majority. That's what I'm saying. You can't use the speaker to win elections. You should stop what you are doing. Honorable Speaker, let me come to very important matters. I didn't know that the majority leader has taken out a suit in the Supreme Court. And in the suit, with the greatest of respect, the Right Honorable Speaker is joined as a party. And there is also an injunction against Right Honorable Speaker. Do you want him to be committed for contempt? If you should go ahead with this matter, is that what you want to do? Do you understand the full implications of somebody hauling the speaker before the Supreme Court and you saying there is an injunction and the speaker should defy the injunction so he's cited for contempt? What kind of indignities are you inviting the speaker to be involved? What is the meaning of this? I don't get it. This is what we are attempting to do. So, Right Honorable Speaker, on the strength of the plaint before the Supreme Court and the injunction, whatever minority leader is trying to do via my vulnerable friend, the former minority leader, has been checkmated. Look, it has been checkmated by the application for injunction. I didn't tell you about the full implications of MOFAT, that when an application is pending before a court and you go contrary to the purpose and the intent of that application, you are in contempt. So I don't know why you are so excited about the fact that, oh, you want to push Right Honorable Speaker to proclaim a declaration so you become a majority. Now let me show you something which is very important. The import of making a statement. When you make a statement, and 93.6, you see, when you make a romancing statement like this one, it is not automatic that Right Honorable Speaker will do your bidding. This romancing thing you did here, you read the order properly. 93.6, where a member makes a statement, the Speaker, considering the comments on the statement, including we informing him that there's an injunction before the Supreme Court, we have told him, may direct, he may. The Speaker is not a conveyor belt for you. He may not. Direct a committee to investigate the matter and inquire into the matter when necessary. So, Mr. Speaker, this is a particular time that you shouldn't not even look at it. That I respect the trinity of governance. The trinity of governance is that we have the executive, we have the legislature, and we have the judiciary. We don't need a collusion cause for Right Honorable Speaker to say there's a plaint at the instance of majority leader and there's an interlocutory injunction to boot. Nevertheless, I will rubbish another arm of government for the sake of the pleasure of somebody who is running away from the polls and believes that this is the forum for him to become majority. So, Mr. Speaker, that's why I quoted the scripture that they want to lead you to temptation. Resist this temptation. I have combed the entire scheme, which is the Quran of parliamentary practice in the Commonwealth. I have never found a statement in a scheme which will make a speaker an extension of the Supreme Court. This is what we are attempting to do. You see, what you want the speaker to do is to interpret the Constitution. That is not his remit at all. And I've heard very jejune arguments that the errors of yesterday. If somebody made a mistake as a speaker, this right honorable speaker should repeat it. You understand? The speaker is not a rubber stamp to come and repeat matters of yesterday, and he can't do his own thinking and distinguish the circumstances, the difference between the situations. This is what we're attempting to do. You quoted a president. Today, have you seen the members of NPP crossing carpet? Have you seen it? Who has crossed carpet? And Honorable Speaker, what is a pain for me? That today they want you to determine what these members of parliament want to do in the future. That is pathetic. Do you know what they want to do? What if they change their minds? So why are you dealing with the future when the now situation is that they've not crossed carpet? How can you pray in Article 97 when the individuals have not crossed carpet? There's no factual basis to support the conclusion that they've crossed carpet. Now you inviting this hollow chamber to consider the pleasures and the wishes of some members of parliament, thinking about post-December 7 and what they want to do. Do you think we play lottery in this house? We don't play lottery like that. We don't do that. So, Honorable Speaker, let me bring to the attention of this house that there's a very dangerous precedent former minority leader attempted to do. And I'm very sad that these lawyers are clever and they want to bring the Choboy arguments into this hollow chamber. These things you can say it when you're on the platform. But let me show you what the Constitution says. Very, very interesting. Honorable Speaker, the governance system of this country are properly demarcated in the Constitution. There is no way one arm of government will usurp the power of another arm of government. So let me read for your consumption Article 130. Subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedoms as provided in Article 33 of this Constitution, the Supreme Court shall have exclusive, not a co-terminal jurisdiction with this chamber. Exclusive. Right, Honorable Speaker, is not an extension of the Supreme Court. And please don't invite him into temptation and push him on the verge of contempt of the Supreme Court. He's a very decent man. He won't listen to you. They shall have exclusive jurisdiction in all matters relating to the enforcement or interpretation of this Constitution. Somebody say we should interpret Article 97. The forum for interpretation in terms of Article 130 of the Constitution is not here. It's in the Supreme Court. And this house is not an extension of the Supreme Court, I'm afraid. (132) where an issue that relates to a matter of or question referred to in clause 1 of this article arises in proceedings in court other than the Supreme Court, the court shall stay proceedings and refer the question of law involved to the Supreme Court for determination, and the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court by parity of reason. Right, Honorable Speaker, the worst thing you can do to avoid this temptation to make a referral, and even you have been joined, so even there's no need for a referral. They've brought you in already. You see, at the instance of the majority leader, you are supposed to hire lawyers and file processes regarding the interpretation of Article 97. So why are they saying you should not, listen to them and then make a referral to a committee for the committee to look at it? Some of them are very happy, afraid of the elections that pronounce majority on their side. Please, with the greatest of respect, Honorable Speaker, I know your gravitas and stature and your pedigree. You wouldn't do that. And those of them who are anxious to have majority here, it is the polls, not here. And I don't want to say more than that because the gentleman who wanted this achieved is my good friend. And the lecturer in law, my dear brother, the lecturer in law, what's his name? Aini, you are saying that there is no factual basis for majority leader to go to court. That's what we are saying. And therefore, you cannot pray in Article 2 of the Constitution. So where is the factual basis in law for the speaker to do what you want him to do? Who would look at the facts? The Supreme Court. So if you want the speaker to give a decision in a vacuum, and I heard somebody say, when the speaker is informed. The speaker is informed about what? What has happened? What is the information about? It is the pleasure of somebody. The information is anemic and hollow. There's no factual basis that people have crossed carpet and say that the speaker should just rubber stamp your so-called information. There should be an evidential basis for the speaker to take that decision. Under Order 18, as is being urged upon you, what is the evidential support for the speaker to take that decision? On the mere say-so of a political platform, Choboy thinking, trying to appease those he was hearing, and they say, oh, I'm going to use the speaker. Oh, my God and King, deliver us. Deliver this. I am leaving this chamber. This is a very hollow chamber. We shouldn't taint it with vile propaganda and empty rhetoric. And I'm very, very glad. I'm going to exit this chamber, God willing, with the speaker. We should keep our name and hallow our name. Right now, speaker, hallowed be your name. I'm finished.
Honorable Ahiapo.
Mr. Speaker, thank you very much for giving me the opportunity to comment on the statement ably made by the minority leader, Honorable Keselato Forson. Mr. Speaker, they are raising procedural issues. I have listened to my brothers from the other side on the procedural issue, and it gives me much interest as how a lecture in metaphysics will give to a newborn baby. Mr. Speaker, the maker of the statement is drawing your attention to a matter of urgent public importance. That is all. So I don't know the hula baloo about the procedural issues. Mr. Speaker, we are governed by rules, and our rules are premised on the Constitution of the Republic of Ghana. Mr. Speaker, the petition being referred to by the majority leader is not before the House. What is before the House is the statement. So I do not know why they are speaking about petition which is not before the House. We should restrict ourselves and comment on the statement before the House. Mr. Speaker, our standing order 18 is under the marginal notes, vacancy other than resignation, and it was based on Article 97(1)(b) to E and G and H of the Constitution. And with your permission, if I may read, the Speaker shall inform the House of the occurrence of a vacancy of the seat of a member under Clause 1(b) to E, G, and H of Article 97 of the Constitution of the Republic of Ghana. Mr. Speaker, it is important for us to look at what Article 97, G and H is saying in relation to the statement made by the minority leader. Mr. Speaker, it says, a member of parliament shall vacate his seat in parliament. G, if he leaves the party of which he was a member at the time of his election to parliament to join another party or seek to remain in parliament as an independent member. Then H, if he was elected a member of parliament as an independent candidate and joins a political party. Mr. Speaker, the statement made by the minority leader is simply saying that the honorable member of Fomena, Honorable Andrews Amwako Esiama, was elected as an independent candidate, but he has filed to contest on the ticket of a political party. If you are here as an independent candidate and you have filed to contest as an independent, to contest on the ticket of a political party, let's look at what the provision is saying in 97H. A member of parliament shall vacate his seat in parliament if he was elected a member of parliament as an independent candidate and join a political party. If you are not a member of a political party or you do not join a political party, how can you contest on the ticket of that particular party? So the issue at hand is whether or not Andrews Amwako Esiama, Honorable, having been elected to this house as an independent candidate, now filing to contest on the ticket of a political party, he has moved to join a political party. And if so, what is the Constitution saying? The Constitution is saying that that member shall vacate his seat. Mr. Speaker, it is mandatory, it is automatic that such a member must vacate his seat. And there is nothing wrong if the minority leader in his statement is drawing the attention of the speaker to that particular fact, so that the speaker can come under our standing order 18 and inform the House about the vacancy of that seat. Mr. Speaker, he is again saying that Honorable Cynthia Mamle Morrison, Honorable Member for Agona West, Honorable Kwajo Ashanti, the Honorable Member for Sohum, and then Honorable Pitaya Okwachi Aka, the Member of Parliament for Amenfi Central, were elected as members of this Parliament on political party ticket. Now, whilst in Parliament on the ticket of those parties, they have decided to go and contest as an independent candidate. And what is the Constitution saying? The Constitution is saying in Article 97G that a member of parliament shall vacate his seat in parliament if he leaves the party of which he was a member at the time of his election to parliament to join another party or seek to remain in parliament as an independent candidate. So in the circumstances, Mr. Speaker, the statement is just drawing your attention to the acts of these members of parliament, which will mean that their seat is automatically vacant. Mr. Speaker, I have listened to an argument that they have not crossed carpet or they are still members of that particular party. Mr. Speaker, they are making that particular statement without reference to their own political party constitution. And Mr. Speaker, with permission, I would want to read Article 3(9) of the NPP constitution, their own constitution. And it's rather unfortunate that senior members of the party are arguing that a member of their party elected on the ticket of their party, now contesting today as an independent candidate, still remains member of their party. At least, let's be honest and uphold our various party constitutions. Mr. Speaker, it's under the marginal note, forfeiture of membership. Article 3(9) of the NPP constitution is under a marginal note, forfeiture of membership. And Mr. Speaker, it reads, a member of the party who stands as independent candidate against the officially elected member of the party, or who joins or declares his or her support for another political party or for an independent candidate when the party has sponsored a candidate in a general or a by-election, automatically forfeits his or her membership of the party. Mr. Speaker, if this is what their own constitution is saying, how can you come to a house of record to argue that members of your party elected to parliament on your political party ticket, now contesting on the tickets as independent candidates, still remains members of your party? What interpretation are you putting on Article 3(9) of your own constitution?
Not being members of their party, how can they remain?
If the person is not members of your party, by mere fact that they are contesting as an independent candidate, how can they remain members of your party? And to say that it is only when you cross carpet that a vacancy can be created, when you cross carpet in the chamber, that one, it cannot be a correct statement. We are lawyers, so let's look at the law and then apply the law to the facts. The fact remains that they are members of some political party. Peter Yaokwachiaka is a member of the NDC, now contesting as an independent candidate. He can no longer be a member of our party, and by our own party constitution, Cynthia Mamle Morrison is contesting as an independent candidate. She cannot be a member of your party. Ashanti Kojo, member of parliament for Sohun, was elected on your party ticket. He is now contesting as an independent candidate. How can he still be a member of your party? So, Mr. Speaker, if you look at the constitution, it's very clear that by the activities of the members mentioned, the seat is vacant. And all that the Speaker needs to do is to come under Standing Order 18 and announce the vacancy. That is all that we are asking Speaker to do. They have spoken extensively on the court action. You see, in the case of Bernard Ahiafo versus the Speaker of Parliament and Attorney General, Bernard Ahiafo and others versus the Speaker of Parliament and Attorney General, this is what the Supreme Court says. Unless Parliament has taken a decision which you feel that decision of Parliament infringes on the Constitution of the Republic of Ghana, they don't have any jurisdiction. Therefore, they won't grant even an injunction. So, they will not intervene in the processes of Parliament. And that should be a guide to my brother in instituting a similar action. Why? Parliament must be allowed to work we all took an oath to uphold and defend the Constitution of the Republic of Ghana. Parliament has a responsibility. The law is clear that when ABCD happen, the seat must be declared vacant. So all that we are saying is that the seat must be declared vacant. This has nothing to do with the December 7 election that we are going to do. As for the December 7, we will form the overwhelming majority by beating you. Mr. Speaker, I thank you very much for giving me the opportunity.
Honorable Ajapa Mesa, am I right?
Right, Honorable Speaker, it's Ijapa Mesa. Speaker, thank you for the opportunity.
Yours is spelled with E, right?
Yes, it is.
Ijapa, yes.
Ijapa.
Yes.
Good father. Speaker, thank you for the opportunity to contribute to the statement that was made by the minority leader. Speaker, indeed, I was driving into the chamber when Joy FM's headline news of 5:30, I believe it's called the news, I've forgotten the name, started airing. And listening to the arguments being made by learned counsel who I expect to be much more candid and uphold the principles that we all studied in law school. I felt rather sad. Mr. Speaker, why do I say this? The principle clearly is that in construing legislation and indeed the Constitution of the Republic and any law for that matter, you ought to put a purposive interpretation to that construction. And so when I hear my friends on the other side argue that Article 97G is applicable in this case, I feel sad. It's as if to say time and the tenure of Parliament is irrelevant in the discourse. And it certainly cannot be. Because the mischief that this provision seeks to cure is clear. It is within the course of the term of that Parliament. So how you construe intentions in the future and say that should be applicable today is baffling. Mr. Speaker, with respect, Honorable Atachia, listening to him, said a lot. And I will urge the House to be guided by the wisdom in his articulation. This is a house of record. This is a hallowed chamber of Parliament. And it's important that we shed our political clothes when we are dealing with matters of this nature. Because posterity is going to judge us. Mr. Speaker, when the previous rulings of the Speaker become binding on the sitting Speaker, indeed, it is not even persuasive. So, how is it the case that people can rely on the ruling of Right Honorable Mike Okwe as basis to make this argument today? Please, it's important that we seek to do what is right at all times. I recall, Mr. Speaker, that people on the other side of the House, when Right Honorable Mike Okwe made those rulings, objected. They supported Honorable Andrew Esiama. So what has changed? How is it the case that they supported Honorable Andrew Esiama and disagreed with the ruling of the speaker then, and now turn around and make it look as if the ruling today that they are seeking for is right. In any event, Mr. Speaker, with respect, this is a statement that has been made under Order 93 of our standing orders. Is it a suggestion then, therefore, that you are to set up a committee to investigate the matter, or merely people making comments or members making comments should suffice for information? Oh, so is that the exercise, the reason for which we are engaging in this lengthy debate? So, Speaker, with respect, my good friend Honorable Ahiafo makes the point that the NPP constitution, he conveniently omits to interpret the entirety of the NPP constitution as a whole. He forgets or conveniently excludes the rights that members have under the NPP constitution. As Speaker, if you permit me, Article 4 and 3 of the NPP constitution is clear that even if members are deemed to have vacated their position as members of the party, they still have a right to be heard. So that reference in itself is inapplicable because it cannot be automatic. So, Speaker, I will urge of you not to fall in the temptation as Honorable Atachia invited you to, that the minority is setting for you today. You need to stand up and be counted. That when it mattered most, Mr. Speaker did not pander to the whims of the minority to make any determination that would be adverse to the interest of the constituents that these members of parliament represent. Mr. Speaker, their intent is futuristic. They have not crossed carpet as the Honorable Wayo Seni did during the time that he was in the Parliament of the Republic of Ghana. I believe it was during the 4th or 5th Parliament, when he stood up in his place and made a declaration that he has ceased to be a member of the NDC and is moving to be a member of the NPP, and cross carpet to join the NPP. None of these members have exercised or done any such act for you to be called upon to make a declaration that their seats are vacant. Mr. Speaker, the facts are clear. These members have not vacated their seats. The NPP has not removed them as members of the New Patriotic Party. They have not petitioned. Nothing that should be urged on you and this House to remove or declare their seats as vacant under Article 97. And I urge you to disregard the invitation and let us move on to deal with important matters of state. I thank you for your time. Thank you.
Honorable Dafiamapo.
Speaker, I am very grateful for the opportunity to comment on the statement ably made by the Honorable Minority Leader, bringing this very important matter to your attention. Mr. Speaker, I can sympathize with the Majority Leader and his battalion that you come to work in the morning as Majority Leader, and by close of business, you are living for the House as Minority Leader. Mr. Speaker, we are urging on you to apply the decision ably delivered by Professor Michael Kui on the 43rd day of Saturday, November 7th, that it is of similar effect and applicable mutatis mutandis in this matter. Mr. Speaker, the constitutional language of joined, as used in Article 97, 1G and H, What are the incidents of joining? Mr. Speaker, let me reference the House to constitutional instruments CI 127 regulation, Mr. Speaker, particularly regulation 14. Mr. Speaker, regulation 14 is in respect of allocation of symbols and colors when candidates file before the Electoral Commission to contest in an election. The processes that happen under regulation 14, Mr. Speaker, is that the Electoral Commission, upon the closure for filing of nomination, allocate symbols and colors, so that under regulation 14(1) of CI 127, where a candidate is sponsored by a political party, that candidate is allocated the political colors of the party that sponsors him or her. Mr. Speaker, under regulation 15 of CI 127, the candidates, Mr. Speaker, are published in what we call the notice of poll. And Mr. Speaker, the notice of poll, the Electoral Commission is constitutionally mandated to gazette it. And in publishing the notice of poll, the candidates as they file are indicated on the notice of poll regarding your position, if you're on the ballot paper. Mr. Speaker, the facts as being narrated points to the fact that the 4 members of Parliament, 1, the Honorable Andrews Amwakwe-Siama, who also happens to be the 2nd Deputy Speaker of this House, serves in this House as an independent member of Parliament. Mr. Speaker, you had cause to pronounce on his decision to caucus with the majority. To caucus with the majority is to do business with them. It doesn't constitute joining as a member. Mr. Speaker, if mere caucusing with them was sufficient, why has he taken the definitive step now to file on the ticket of the NPP and to be sponsored by the NPP? Because that constitutes joining properly so-called under law. Mr. Speaker, there's operation of automaticity of law. That's right. And when we are reading the Constitution, Mr. Speaker, we are enjoined to interpret the Constitution as a whole, and we also read it as a whole. In reading the entire Article 97 as a whole, Mr. Speaker, these are the incidences that the framers point to. Article 97(1) says, a member of Parliament shall vacate his seat in Parliament. A, when upon the dissolution of Parliament. Mr. Speaker, when there's a dissolution of Parliament, you don't have to go to the Supreme Court for an interpretation. It is automatic. You cease to be a member because the incident, the action of dissolution of Parliament has occurred. So there's no need to call in the Supreme Court to interpret anything. B, if he is elected as Speaker of Parliament, Mr. Speaker, when Speaker Joe Ajaho as a member for Akachi South got elected as a member, by operation of law, he ceased to be a member of the House. And the Honorable Ahianfo, who is before us here today, got the opportunity to be elected to replace him, as it were. That is operation of law. There was no need for anybody to go to the Supreme Court to seek an interpretation as to whether or not upon the election of Honorable Dua Ajaho as a member of Parliament, as Speaker of the House, whether he had to vacate his seat. That is automaticity of law. Mr. Speaker, D, if the member is expelled from Parliament after having been found guilty of contempt of Parliament by a committee of Parliament, Mr. Speaker, when that happens, it is automatic. You leave. There's no need for a Supreme Court to come in. Mr. Speaker, if we go to E, I haven't abandoned E. F, if he resigns from office as a member of Parliament by writing under his hand addressed to the Speaker. Mr. Speaker, when this happens, this house cannot be debating this matter. That a member has resigned under his signature, and whether or not by resignation there's a vacancy in respect of his seat. It is automatic. Mr. Speaker, so it is automatic that under 97(1)(g), if he leaves the party of which he was a member at the time of his election in Parliament to join another party. Mr. Speaker, we are saying that these members have joined another party or have departed from the party that sponsored them and brought them to Parliament. Mr. Speaker, in making all these arguments, let me read in extenso the rendition by the Honorable Professor Michael Quay on the very faithful day of November 7th, 2020. Mr. Speaker, I hear this to say, honorable members, before our visitors come in, there's a ruling I have made on the petition for the declaration of the Formina seat in Parliament as vacant. Parliament is in receipt of a petition from the General Secretary of the New Patriotic Party, NPP, inviting the Speaker of Parliament to declare the Formina seat in Parliament vacant. Mr. Speaker, the Member of Parliament, Honorable Andrew Amwakwe-Siama, who has been written to, has responded accordingly, and copies are attached to the ruling. The NPP invoked Article 97(1)(g) of the Constitution of the Republic of Ghana 1992, which provides that a member of Parliament shall vacate his seat in Parliament if he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent member. The Constitution of the NPP, which the MP freely subscribed, provides in Article 3, Clause 9, Paragraph 1, that a member of the party who stands as an independent candidate against the officially elected member of the party, or who joins or defects his or her support for another political party or for an independent candidate, when the party has sponsored a candidate in a general by-election, automatically forfeits his or her membership of the party. The moment the MP filed his candidature with the Office of the Electoral Commission to contest the next election as an independent candidate, it shows clearly that he seeks to leave his party. This automatically triggers forfeiture of his party membership. He cannot have the desire. Mr. Speaker, I believe that we need to listen to your predecessor here. He cannot have the desire to leave, take a step towards it by filing as an independent candidate, and yet claim to be a member of the party. The step taken to contest against his party automatically triggers forfeiture of membership. Having forfeited his membership of the party on which ticket he was elected to Parliament, the operative language of the Constitution is that he shall, which is mandatory, vacate his seat in Parliament. Going by a purposive interpretation of the present law, constructive action on the part of the MP is important. With all intents and purposes, he is no longer a member of the party. He has pronounced himself publicly as an independent candidate and has filed papers to compete against the party and its official candidate as an independent candidate on 7th December 2020. On that occasion, this current parliament will still be sitting and operating as an official parliament of the Republic of Ghana. We shall not have a situation adopted freely by any city MP where he or she would be campaigning openly against the party that he or she still represents in parliament, and yet ridiculously stands against the party. No purposive interpretation of law will allow such a ridicule to prevail. Mr. Speaker, furthermore, after 7th December 2020, when Parliament is still in session till 7th January 2021, how does an MP operate both as an elected independent MP and at the same time an NPP member if he should win the election? This lacuna of a ridiculous situation is not what is anticipated under the 1992 Constitution. In the circumstances, it is determined that the conduct of Honorable Andrew Amakwesiama amounts to vacating his seat in Parliament. Accordingly, we bring this to the notice of the Electoral Commission for the necessary action to be taken in accordance with the law. Signed, the Right Honorable Speaker. Mr. Speaker, the gravamen of this argument is eruditely captured by the ruling of Professor Michael Quay. Mr. Speaker, to conclude, we are saying that the matters as envisaged by the Constitution in Article 97 are clearly given birth by the conduct of our four colleagues. And Mr. Speaker, we are only urging upon you to enforce the decision ably given by Professor Michael Quay on 7th November 2020. Mr. Speaker, which decision has remained unchallenged and remained good law and has guided this House ever since. So, Mr. Speaker, I will want to pray you that the need to elect another deputy speaker, which must come from NDC side because of Article 93 of the Constitution, is rife. And I believe that awareness, that reality, is what has shocked the conscience of our brothers. And they must know that the Constitution, the enforcement of the Constitution, is our above duties that we must uphold. Mr. Speaker, with these words, I thank you for the opportunity.
Yes, I think they should end it. I will allow the chairman of the Committee, Constitutional, Legal and Parliamentary Affairs. No, Constitutional and Legal. Yes, you can make your comment. And then who?
Thank you, Mr. Speaker.
That means he will speak for and on behalf, and that will be the end. Okay. Yes, please.
Thank you, Mr. Speaker. Mr. Speaker, this is very interesting. And Mr. Speaker, you have allowed us, and I'm grateful that you've given me an opportunity to comment on this. Mr. Speaker, looking at the procedure under which the application had been made before you, I was tempted to believe that this exercise, apart from comments, is much ado about nothing. The Article 93, under which the applicant had made this application, Order 93, Mr. Speaker, and other speakers had said it, that 93(6) says, where a member makes a statement, the speaker, considering the comments on the statement, may direct a committee to investigate and inquire into the matters, and where necessary, propose legislation. Mr. Speaker, I think the effect of this is to enrich our laws. The provisions under Article 97 were put into the Constitution historically because of what have happened in the nation. Mr. Speaker, in the First Republic, people were just literally living from one political party to the other. And Mr. Speaker, you are a veteran in this house, and I would want to remind you of Wayoseni, who physically crossed carpet to the other side of the aisle. Mr. Speaker, that was the purpose of such a provision, that people must not cross carpet during the session of the parliament. We are in the 8th parliament, and we are preparing to go for the 9th parliament. The intention, therefore, is that whilst we are in the 8th parliament, you cannot cross carpet to the other side of the aisle. Mr. Speaker, this is what the Constitution is preventing. Now, my colleague had read the ruling of the then Speaker in greater detail, and I think that with a greater respect to the learned professor, Mr. Speaker, I think that if we are listening to him very well, and I don't want to bore you to read through, most of the things are contradictory in the ruling. Mr. Speaker, a portion that my colleague read reads, the constitution of the NPP, which the MP freely subscribes to, provides in Article 931 that a member of a party who stands as an independent candidate against the officially elected member of the party, or who joins or defers his or her support for another political party or for an independent candidate when the party has sponsored a candidate in a general or by election, automatically forfeits his or her membership of the party. Mr. Speaker, let us not forget that the NPP as a party petitioned the Speaker of Parliament then that Honorable Andrew Amakwa-Siama had been removed as from the party because he had crossed carpet to the other side. And the NPP referred to its constitution, and this is what Speaker Mike Okwe was referring to, not any other constitution. Mr. Speaker, the learned former Speaker referred us to Article 55.5, and with your permission, I may want to read. 55.5 says that the internal organization of a political party shall conform to democratic principles. Sorry, at 55.6. An organization shall operate as a political party unless it is registered as such under the law for... No, that's not what I want you. Every political party shall have a national character, and a membership shall not be based on ethnic, religious, regional, or other sectional divisions. And it goes on to say that political parties, with the political parties would organize its own internal affairs with law. And that is what Professor Michael K. was referring to. In the Hansard, Mr. Speaker, it was referring to the new Patriotic Party Constitution. And the new Patriotic Party Constitution, which they petitioned the Speaker that the gentleman, that is Andrew Asiama, had violated the NPP Constitution. And the NPP removed him as a member of the party and went ahead to tell the Speaker that they had removed him. Mr. Speaker, what we have and the processes and the procedure that have been used is a comment by a member of Parliament, not petitioning the Speaker, not petitioning Parliament, just saying that he thinks that a member had filed. Mr. Speaker, we are in the 8th Parliament, and everything that any person plans to do.
Yeah, Honorable Chairman, I think in trying to quote the Constitution vis-a-vis that of the NPP Party Constitution, you seem to have maybe slipped and not gotten the article rightly. So you didn't get enough time to go back to read it. I think that is what has ignited Honorable Bernard Ahiafo to be on her feet. So I'll give him the chance to draw attention to what it is. Please, Honorable.
Mr. Speaker, thank you for the opportunity. Mr. Speaker, the ruling of Right Honorable Professor Michael Kwe is very clear. It's stating that based on Article 391 of the Constitution of the NPP, the member who has decided to contest as an independent candidate ceases automatically to be a member of the NPP. It is for that reason. That's why the Secretary, the General Secretary, is invoking Article 97(1) of the Constitution of the Republic of Ghana to declare the position vacant. So you need to come clearly about what the ruling of Right Honorable Makokwe is saying.
No, but the issue the chair was drawing attention to is that the statement was contradictory. And he was trying to read Article 55(5), which deals with the democratic procedures of each political party in handling such matters, which, according to him, was not adhered to by the NPP. So he was trying to say that those provisions were contradictory. The position taken by the former speaker vis-a-vis the provision in the party constitution and that of the constitution. But he didn't get it right. So I really understand why you are raising your point of order, but please let's allow him to continue.
Thank you, Mr. Speaker. Mr. Speaker, where the distinction I want to draw here is that no political party had petitioned this House, and no political party had removed any person from his membership, and nobody had complained before this House. What we have this afternoon before us is a comment that a member of Parliament, a statement that a member of Parliament had made, and we are invited to make comments. And Mr. Speaker, I think this would not give us or would not give you the right to pronounce on the fact that a member of Parliament, a seat of a member of Parliament must be declared vacant. Mr. Speaker, under the rules, under Order 93, the best that can happen is for this matter to be referred to a committee. And if anything, if there is any mischief that this comment, the comments in addition to the statement would seek to cure, Mr. Speaker, then it may lead to a law. And as I would want to repeat, Mr. Speaker, that apart from the provision that I have referred to, I think that this exercise is much ado about nothing. In the end, Professor Mike Okwe's ruling, and I would want to read the last but one column that he says. He says, further, after 7th December 2020, when Parliament is still in session, till 7th January 2021, how does an MP operate both as an elected independent MP and at the same time an NPP MP if he should win the election? He goes on, the lacuna of a ridiculous situation, this lacuna of a ridiculous situation is not what is anticipated under the 1992 Constitution. End of quote. Mr. Speaker, I was a civil servant when I was elected as a member of Parliament. When I was elected as a member of Parliament, I did not breach any law until I became a member of Parliament of this House on 7th of January 2009. Meanwhile, I was elected in 2008, December 2008. Being elected as a member of Parliament is different, Mr. Speaker, from being a member of Parliament. And I do not think that it will cause any problem. And besides, when he concludes, he refers the matter to the Electoral Commission to take action. Mr. Speaker, we were in this House. We didn't see anything. That's why I said that I would say the ruling was a shows, and Mr. Speaker must not be invited to go by that. Mr. Speaker, I'll refer, before I sit, I'll refer, Mr. Speaker, to Article 99(1) of our Constitution, and it says, the High Court shall have jurisdiction to hear and determine any question whether a person has been validly elected as a member of Parliament or the seat of a member has become vacant. Mr. Speaker, so these matters, Mr. Speaker, if anybody would want to say that a seat of a member is vacant, I think the person must walk to the court and for the court to make a determination. When the learned majority leader had informed us that he had gone to the Supreme Court to seek interpretation of a law, he is right. He has a right to go to court, and anybody can go to court and ask for interpretation of any clause that he doesn't understand. Thank you, Mr. Speaker, for giving me this opportunity.
Yes, Honorable Cletus Avoka.
Thank you, Mr. Speaker. Mr. Speaker, I'm grateful that you have given me the opportunity to make some few remarks with regards to this issue. Particularly so when I was a member of the Consultative Assembly, the defunct Consultative Assembly, that had some reason behind some of the provisions that we had made. Mr. Speaker, I'm going to argue on two main grounds. One, on the spirit and letter of the Constitution of 1992, and 2, on common sense, practicality and common sense. If we apply practicality and common sense in this matter, we will not have been laborious as our opponents on the other side have subjected us to this evening. Mr. Speaker, if you look at Article 1, Chapter 1, Article 1 of the Constitution, it is referring to the sovereignty of the people of this country. That whatever we do in this country, whether in the executive or by the executive, the judiciary and parliament, we should know that we derive our authority, our strength, and our power from the sovereign will of the people, and not from any other source. So whatever we do, we must have recourse to the people who are giving us the power to undertake those activities. Having said so, Mr. Speaker, let me read Article 1.1 to you and to my colleagues. The sovereignty of Ghana resides in the people of Ghana, in whose name and for whose welfare the powers of government are to be exercised in the manner and within the limits laid down in this Constitution. So the sovereignty of the whole country rests with the people, is vested in the people. Now, if you look at Article 35(1) of the same Constitution, that is with the directive principle of state policy, that deals with political objectives. Article 35(1), Mr. Speaker, says, and I quote, "Ghana shall be a democratic state dedicated to the realization of freedom and justice, and accordingly, sovereignty resides in the people of Ghana, from whom government derives all its powers and authority to this Constitution." And finally, Article 125 of the Constitution, Mr. Speaker, established this issue of sovereignty resting in the people that I'm talking about. Article 125. It deals with the judiciary. Article 125(1). Justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to this Constitution. So the combined effect of these 3 articles in the Constitution that I refer this August House to is indicative of the fact that whatever we do, we must have recourse to our people. So it is the people in every constituency belonging to a particular party that goes to primaries to elect a representative to represent them in the elections. After the primaries, it is the same people who, in the general election, elect somebody to come and represent them in this August House. It is the same people, if you stand as an independent candidate, then they rally behind you and elect you to come to this House because they have common objectives that they want you to come here and articulate. So, if you come to this August House and you have to leave or you have to go and join another party for an election, whether as a party member or you are going to become an independent member, it seems against the principle of not contacting the sovereign will of the people, or you have betrayed the sovereign will of the people. You have disparaged the interest they have given you. You and them had a package. Our 4 colleagues who are here and some are going independent, others are coming to a different party, they have had a package, they had a pact, they had an agreement with their respective constituents to come and articulate and support a particular party for 4 years. So if 3-4 months to that, they are not coming to an end, you go and betray the party and then now to belong to a different party or to belong for a particular interest. You have betrayed the people, you have betrayed the trust they have reposed in you, and therefore you cease to be a member of that party from the day that you file your nomination with the Electoral Commission. The day that you file your nomination, you cease to belong to that party. And therefore, Article 97 comes into play. Mr. Speaker, so the Constitution had done that because they wanted us to depart from the practice that we had in our First Republic and other jurisdictions, where people were elected on their party ticket, They came here, and because of their personal interest, because of persuasion, because of hope of advantage, because of inducement, because of corruption, they jumped to another party without reference to the people who brought them to the August Parliament. This is what we wanted to prevent. People from jumping from one party to the other. People from auctioning the mandate they had from their constituencies to come and represent here for their personal interest or welfare. We wanted to prevent that. That is why Article 97 was provided. That is why Article 135 and then 125 were provided. That the will of the people, the decision of the people is supreme, is sovereign. And therefore, whatever you do, you must have recourse to them. With the greater respect, Mr. Speaker, these four people did not have recourse to those who brought them here and decided on their own initiative to abandon their parties and go independent or change another party. And therefore, having done that, they have lost their position as members of their respective parties, and therefore, Article 97 catches them. Mr. Secretary, having said that, the common sense aspect of it is this. Before you go to file your nomination with the Electoral Commission, you have to have a letter from the political party, from your party. The question is, those who are going independent, which party did they get letters to go and file? So, can a party file two candidates? No. The NPP had filed their party candidates with the Electoral Commission. NDC, we had equally done so. So, having filed for a different party, you cease to belong to that party. That brought you to this August House. Having filed as an independent candidate, you fail or you have ceased to belong to that party. That brought you here. Or to the group, you have betrayed the group that brought you here. And therefore, you don't belong to them again. And that is squarely caught by Article 97 of the Constitution. Mr. Speaker, having filed your nomination, let's be very fair. I'm talking about common sense. Is the NPP or even we here saying that if we are going to have a caucus meeting to strategize on how to win the election, those who left our parties here and have filed an independent rep, we will invite them to that meeting? No. You will not invite them to that meeting. You will not invite them. Mr. Speaker, the Vice President, Dr. Mahmoud Baba, is going around campaigning. Are we saying that, are we suggesting that the MP for Suhum and the MP for Cynthia, Agona West, I go around with him campaigning on what ticket? And what ticket? On what ticket? And similarly, the MP from our side in the Western North region, without common sense, that they are no more belonging to those parties. They have ceased to belong to those parties. And you don't need to wait until 7th January 2025. That doesn't make sense. Besides that, Mr. Speaker, if we are allocating resources now, whether the NDC or NPP, to their parliamentary candidates, will they allocate resources to those who have left their party and are standing independent? They will not. So common sense. Mr. Speaker, with the greatest respect, I think that the ruling by your predecessor, I wasn't here in 2020, but I've listened to it. The ruling that Professor Maekwe gave was very lucid and sound. And I get surprised that those who were hailing him in 2020 for that ruling are people who are now crucifying him. What people are we? You who were hailing the ruling in 2020 are now those who are hailing, crucifying the same professor. Are we serious? Are we sincere? Mr. Speaker, what is killing Ghana today is corruption. It's corruption. Do we want to propose institutional corruption that you go and then ask people for a mandate and they give you with certain terms and you come here and pocket some money and then betray them? Is that what they want us to do? That is institutional corruption. That is what we want to prevent under the 1992 Constitution. And I thought that we should praise the 1992 Constitution, particularly Article 97. That said, you cannot take the people's right for granted. You cannot betray your people when you come here and want to chop a loan. That is the correct provision we have made, including several others. So for us to get up here and say that, in 2020 it was correct, but in 2024 now, it is not correct. That is double standards. Double standards, which cannot be attributed to the August House or members of this August House. So, Mr. Speaker, it's my humble submission that these our 4 honorable colleagues, once they have filed with the Electoral Commission, they have ceased to belong to their respective party that brought them here or their constituent that brought them here, and therefore, once they have ceased to belong to those parties, they have become they have ceased to become members of this August House, and therefore they could go home, and then we can have our peace. They should go. Yes, there are no more members of Parliament. In that regard, tomorrow, Mr. Speaker, my humble submission that the minority leader becomes the majority leader, and then we become the majority side. Because he who comes into equity must come with clean hands. Where are your clean hands? Where are your clean hands? When we were hailing the decision in 2020 and 2024, you are backtracking. Where are your clean hands? Common sense. Thank you, Mr. Speaker.
Honorable members, I have listened to the comments from members after the minority leader submitted before the House a statement under Order 93. Both the statement and the comments have raised quite serious issues of procedure and substantive law. And I think I need time to go through them, because what I believe is that do unto others as you want others to do unto you. And when you plant evil, you reap evil. And so I want to take a few days to submit a reasoned ruling in this matter. I see that this is not only an urgent matter, but a very serious national issue. And there's good reason why the constitutions after the 1968 Constitution differed, because of the issue you are raising of some refer to it as cross-carpeting, others say crossing carpet. They refer to one and the same thing. So please, having gone through all these constitutions and having gone through all these parliaments in the Fourth Republic, and having experienced all what you have stated, I think I'll have to do justice to the subject. And so I need to present to you a very well thought out ruling, so that tomorrow I will not either be crucified or hailed, but the right thing would have been done. So I thank you all for taking your time to submit to us your understanding of both the procedure and the substantive law. My attention was drawn to this by the leaders that it is a serious matter. And it's true that the Honorable Haruna Idrisu gave me a copy of a notice of a petition on this matter. It was not a petition, it was a notice of petition. And you know through our procedures how they should be processed. And that is being done. That is different from the statement that has just been made. Even though the subject matter is the same, the procedures are different. It's also true that the majority leader drew my attention to the fact that he has sued me. Me, not Alban Sumana Kingsford Bagbin, but Speaker of Parliament. That office, not me in person. And so he's taking that to the Supreme Court. I also listened to the comments on the proper venue. Those of you who commented talking about the High Court and the determination of these matters. The other disagreeing with his procedure of going to the Supreme Court. But the reliefs are quite different from what he said, what he told me, because I have not been served with the process yet. And so that is still not before me. So please kindly give me these 2 days and I'll come here with a well-written ruling. I will submit it to all of you so that at the end of the day, justice would have not only been done, but would have been seen to be manifestly done in this matter. Yes, please.
Mr. Speaker, very humbly, I think that it will be fair that having made reference to the suit in my submission, and same having been referred to in your comments soon thereafter, as has been the practice of this House, it is appropriate that same is made available to the table office. So, Mr. Speaker, with your leave, it's a document that, Mr. Speaker,
Majority Leader,
Mr. Speaker, may I finish, Mr. Speaker?
Majority Leader.
Mr. Speaker, may I finish? Now, Mr. Speaker,
please.
Mr. Speaker, these are the gentlemen who are seeking justice, and are obstructing justice. These are the gentlemen who some minutes ago were talking about justice. See them. See the lawyers amongst them. Mr. Speaker, I need to make my point, and I will make my point. I will need to make my point, and I will make my point. Mr. Speaker, this practice that when we are up on our feet, they will get up to obstruct must end. This must end. Mr. Speaker, what I am saying is that I referred to my suit in my submission. In your comments, you referred to the very suit that I filed at the Supreme Court. I am saying that as a House, the practice has always been that when you refer to a document, you make the document available to the House. Mr. Speaker, I am therefore seeking your leave to enable me make the document available through the table office so that it becomes part of the Hansa. Mr. Speaker, soon after my submission, Hansa department sent a lady. They came here with this, that they want this suit, and then the petition I read. They referred to the Haruna Idrisu's petition. This is the notice they brought. It's here. Mr. Speaker, the notice of your petition. They brought this note. Mr. Speaker, Hansa brought me this note that they need this document. So I'm only being fair and candid by saying that in view of this, I want to tender this Make it available.
Honorable Majority Leader, this is complete abuse of process. I decline to grant you the leave. There is no rule permitting you at this stage, during this statement, to deliver or submit a paper just because somebody has referred to that paper. So please, that is not the practice, that is not the procedure. Honorable Member, your gesticulation will not change my decision. Please. Please. In the comments, you are referred to so many documents and so many lessons. Nobody during statement and comments will call on you to lay the document. Where is it done? It's not done anywhere in the world. There's no practice, there's no rule like that. Please, the proper thing will be done. The issue is before the court. The court believes will proceed to serve, and we have discussed this with the Chief Justice. The Chief Justice has given a directive, in fact, instructions to all registries in the country. And so they are following that. And at the appropriate time, those documents will be made available. And I think that the Hansard Department are also jumping the gun. Once the matter is mentioned, and you do so in the Hansard. You don't proceed to ask for the document just because somebody has mentioned the document. Then your Hansard will be such that will not be able to read them. Please, whoever is behind that must stop. That's not parliamentary practice. Please, I have not granted leave.
Mr. Speaker, with respect, I shall yield to the position you've taken and have back the document. But Mr. Speaker, I want to underscore the point that the request that came was to the effect that because I have mentioned they would need the two documents, and this is the notice that was served on me. But Mr. Speaker, we still deal with gray areas. We still deal with gray areas. And I will be happy to always learn. Because after all, that was the encouragement you gave to us when you were the majority leader and we were young backbenchers in this chamber. Mr. Speaker, it is true that when statements are made and comments are made soon thereafter, documents are referred to in submissions, and they are not necessarily to be tendered. However, Mr. Speaker, as you underscored, we are dealing with a sensitive constitutional matter. Mr. Speaker, today it may appear as though we are, arguing for the sake of argument. But posterity will come and refer to this. Mr. Speaker, I remember, Mr. Speaker, Mr. Speaker, I remember how Honorable Ayariga opposed vehemently the decision of Speaker Okwe. But today, in his argument, he says that we should worship that decision. I remember in 2020. I remember all of that. But Mr. Speaker,
Honorable Majority Leader, don't reopen this.
Mr. Speaker, I'm not.
Please.
Mr. Speaker, I need a broad smile from you. That's all I want.
Please.
Then I'll withdraw.
Honorable members, Parliament is the highest platform for political discourse. So sometimes we understand this situation. And I'm happy that members don't take this to heart, and that after that, you still are the best of friends. So let's continue along that line. I will now beg of you for us to call it a day, unless you want us to continue.
No, please. Mr. Speaker, we agreed to lay some papers, please. Mr. Speaker, we agreed to lay some papers. I mean, that was the agreement we had. Mr. Speaker, I therefore...
Yes. Thanks for reminding me. We have some instruments that we have to lay because of the issue of 21 sitting days.
Yeah, sure.
And those are very critical instruments to be laid. So I'll grant permission for that to be done. Honorable members, at the commencement of public business, that is item 9 on the order paper. We finish 8, which is statements. Item 9, presentation of papers.
Go
at the commencement of public business.
Go ahead.
The following papers to be presented by the majority leader. 9 Roman 1 and 2.
Annual statement by the Audit Committee. By the Audit Committee of the Public Services Commission for the year 2023.
Table office, I didn't hear Roman 1. I think the mic went off. So please, if you can go over that again.
Annual statement by the Audit Committee of the Ghana AIDS Commission for the year 2023.
Honorable members, both papers have been laid accordingly and referred to the Committee on the State, is it State Enterprises? These ones, State Enterprises. Honorable members, I have to get the complete title of the committee. It's a new committee we established. I think these are documents to be referred to the Committee on Public Administration and State Interests. Public Administration and State Interests for consideration and report to the House. Now we'll take item 10, presentation of instruments. 10A by the Minister for Finance. Yes.
Thank you very much, Mr. Speaker. Mr. Speaker, I want to seek your leave for the Minister of Interior to lay the instrument on behalf of the various ministers. The Minister of Tourism, sorry, Mr. Speaker. Andrew Mesa.
Any comment from the other side? If not, we go on. Yes, Minister, you may do so.
Fees and Charges, Miscellaneous Provisions, Amendment Regulations 2024.
Honorable members, they said regulations refer to the Committee on Subsidiary Legislation for consideration and report to the House. I want to add that the Committee on Finance and Economy should at least assist the committee on the subsidiary legislation, because these are dealing with taxes and charges, and they may be helpful to you. 10B.
Corporate Insolvency and Restructuring Regulations 2024.
Honorable members, this is also referred to the Committee on Subsidiary Legislation and the Committee on Constitutional and Legal may also be supportive of this committee on these matters. I was being advised by the clerk to limit it to only the leadership of the committees. But I'm aware that some members of the committees, some members are interested in these matters and they always want to support. So when you limit it to the leaders, you prevent them from doing so. Even though our rules say that members are at liberty to attend the sitting of any committee of the House. It's just that you don't have a voting right there. So we go to 10C, the Prison Service Parole Regulations 2024, Minister for the Interior.
Prison Service Parole Regulations 2024.
Honorable members, this is presented by the Minister for Tourism
and Culture.
Tourism, yes. For and on behalf of the Minister for Interior, Tourism and Culture, referred to the same Committee on Subsidiary Legislation for consideration and report to the House. 10D.
Petroleum Downstream, Ghanaian Content and Ghanaian Participation, Regulations 2024.
Honorable members, these regulations are also referred to the Committee on Subsidiary Legislation for consideration and report to the House. Members of the Energy Committee, you are encouraged to go and support the committee. Yes. Any more? Yes, please.
Come on, use this one.
Mr. Speaker, thank you for the opportunity. Mr. Speaker, just for the sake of clarity, in referring the instrument under 10A to the Committee on Subsidiary Legislations, you specifically directed that the leadership of finance and economy should join. But in respect of corporate insolvency, I heard you clearly that it's like a joint referral to the Committee on Subsidiary Legislation and the Committee on Constitutional, Legal and Parliamentary Affairs. So I wanted some clarity there.
It's not a joint referral. Okay. It's the same.
Okay.
It's
Also,
referred to the Committee on Subsidiary Legislation. But I encouraged members of the Committee on Constitutional and Legal to go to assist.
Participate. Very well. Thank you. I'm guided.
Honorable members, any more?
Mr. Speaker, we are in your hands.
Honorable members, then we'll proceed to adjourn the House to tomorrow at 10 in the forenoon. The House is adjourned accordingly.